that question. In my brief, I specifically say I'm asking for a remand back to district court to address the two issues, which are the two statutes I mentioned in my opening argument, which is the modem ban, which is 206.845. So I'm asking for a factual determination, discovery, and so on whether that ban was violated. And then I'm also asking for district court determination on statute 206.57.
Can I just ask about the modem ban just quickly?
Yes.
Was that actually brought up I didn't see that brought up in your complaint. That seemed to be added later on. You made the argument about the examination and approval and the fact that it wasn't tested.
Yep.
But the modem ban was not kind of brought up until well into the proceedings. And I just want, am I factually correct about that? That's how I read the papers.
That's a fair observation of the record. Okay. When I made when we asserted the original complaint, we were going in quickly because we were worried about latches, and we were gathering evidence as quick as we could. And quite frankly, some of the evidence came from third parties that Ms. Anderson had been communicating with, but I hadn't gotten the information, so I got this information through kind of a third-party source. So you're right, I didn't plead the modem ban, but it does come back to, I said that they that modems are a problem, right? So modems are a problem, they haven't been examined, they haven't been used properly, and so I feel like notice pleading, I did bring it up.
Okay, and then I apologize, because I interrupted your answer to Justice McKagan, so maybe
yeah.
I think you were on the 206.57.
I was going through each statute, yes. So 206.57 requires examination and certification of voting systems in Minnesota. Our proposition is that a modem embedded in a machine that's used to tally and report votes is clearly part of a voting system that should be subject to the Secretary of State.
Can I just ask about that?
Yes.
Too? So that examination and like approval or report or whatever, that's the Secretary of State's obligation,
Correct.
Right?
Correct.
And once the Secretary of State says, wrongly or rightly, whether the Secretary of State is correct or not, they've approved it saying this is legitimate or this passes, it's consistent with the law. What either obligation or even what authority does Ms. Anderson have to say the Secretary of State is wrong? Do you understand what my question is?
Yes.
I don't see that duty. Like if it's a Secretary of State's job
yes.
and they screw up, I don't know why it's on Ms. Anderson to like say, this is not, anyway, to the county to come in and say, I think the Secretary of State is wrong, and so I'm not going to use this machine. Where does that come in?
It comes in because the Secretary of State did intervene, and they became a party to the action very quickly.
I'm talking about so it's just the claim against the Secretary of State on that now, and not the okay.
Well,
I was going to say, because you still have her in the picture. I had the same question. What is she going to go say to the Secretary of State? Thanks, but but no thanks.
She's relying on a certificate that says these machines are certified for use, except for at the bottom, there's a specific disclaimer that says this does not cover the use of modems, okay? And so arguably, she has a certificate that she's relying on to say, I'm gonna use modems even though they're not in the certificate. And so I do think both of them have an obligation to make sure they're following the law. I think the certification requirement certainly is driven by the Secretary of State's office, and they've made it very clear in the record. They think they've done nothing wrong. They have full authority. I got a full record where, actually a pretty complete record considering I haven't done any discovery, that there is sufficient evidence to overcome summary judgment to allow us to go in on that issue. So Justice Thiessen, you're correct. It is a primary Secretary of State obligation, but the clerk relies on the certificate.
So when she saw that exception, she should have second-guessed whether the report was accurate.
Exactly.
Okay.
Counsel, can I ask maybe a more fundamental question? Can you spend like a minute explaining to me, I mean, I intellectually get it at a very high level. What does a modem do?
In this particular circumstance?
In this particular, yeah, what's the issue? What,
Okay.
what does a modem do? Explain that to me.
Yes, and so historically in Minnesota, you'd go to your precincts and you put your vote in there and you get the tally, and they take these little thumb drives, right? And they take the thumb drives and they drive them to the central location, and they tally the votes at the local collection point. A number of years ago, like I said, there's 5 counties in Minnesota now that have adopted this new early reporting system. It's Hennepin, Anoka, Washington, Rice, Cass, Stearns, Carver counties. And they started this new system through this ES&S company where they have modems embedded in the machines, and they use those modems to transfer these early results from the precinct to the central location at the county to compile the votes.
And can I just ask on, come back to the modem ban, doesn't it expressly allow exactly that?
Thank you for that question. It does. But as the record establishes, they've gone further, right? So they've taken those results and not just tallied them and then uploaded them through their normal process. They've taken those results and they're sending them to the Secretary of State early for this media program, right? So a few years back, everybody decided they wanted results quicker. And so they're sending these early results to the Secretary of State, and he's broadcasting them to the media. And in the record, it's established, they admit that, that they're providing access to those results.
So that happened before kind of because before you can turn on the modem, you have to do the kind of download the results and have like a paper copy of them.
That's correct.
And so is this media thing going before that happens, or?
Well, it's after.
So they've downloaded the results. There's a hard copy of the results. So your concern is you're going to mislead the public somehow?
My concern is that, first of all, they're just using modems in general. But for that very narrow purpose. But we also haven't, Justice, we're into the weeds here, but I also haven't seen their logs to see when they turn on and when they don't, because through discovery, it's possible those modems are being activated or being.
Do you know, has the Secretary of State approved, do they have to approve the machines every cycle? Like, do they have to approve this machine this cycle again? Or once it's approved, the machines that Rice County is using, they're approved for all time?
Excellent question. If they stay with the same configuration of machines, if they change the model or the software, or they make any kind of a significant change, it's pretty broad, then they have to recertify them. But Rice County has used this same version of their machines for modern history, and I've received no indication they're going to change that. So no, it's not an every time. It's just the first time that new model gets approved, they have to examine and certify.
So counsel, still help me, this is helpful, but one last piece. What is the mischief that you are concerned about?
I don't think I have to prove mischief.
You don't, but I'm just trying to understand the bigger picture of what we're dealing with.
In my opening argument, my point is that we're in a modern world, right? And so
mischief was probably the wrong word. What is your concern? What is it that you are concerned about?
So in the modern world, I'm a business attorney, not a constitutional lawyer, so I'm glad we didn't get too deep into that. But, and so in my world, in the business world, we spend all our time protecting businesses, and they're worried about cybersecurity and with all these huge high-profile issues. And I think we should be concerned as a state, and the court should, that eventually, as I pointed out, there's going to be some type of a snafu or something's going to happen. Last election, there were a couple reporting issues that caused some confusion, and that didn't end up on your desk. But I think eventually, with this technology evolving, and the rest of the business world is worried about infiltration and hackers, and I think we should be too. I think election officials should be likely concerned, and I think the court should be prepared for that.
Counsel, aren't you asking us right now for an advisory opinion, given that there's nothing we can do about the 2022 election at this point, and we're not yet to the 2026 election?
Again, I think I started to answer that question. Mm-hmm. I'm out of time.
But please go ahead.
And so, I think as I've argued, I gave notice pleading, I've designated the next election. I think we are ready, and this case is ripe for full judicial review at the district court level. I don't think you can say it's moot. Like I said, when am I, if you're going to tell me I filed at the wrong time, please give me some guidance on when I should file it again. Because again, we need time to develop a district court record. We need a chance. This could get remanded. We could have a hearing and a decision, and it could go up on appeal again. I think that's what, that's the gold standard for judicial review is district court develops a record, you take it up on appeal, we deal with our, motions in limine and all those type of issues. And I think that's what I'm asking for is let's create a process where we can be thoughtful about these type of questions.
Mr.